on behalf of Dean Michael Hunter Schwartz, let me welcome you to this KCon Zoom panel on contracts in the 21st century. We have a number of really interesting speakers and speeches to go through. And I think from one angle or another, they tell us a lot, both about what is happening to contracts, law, and policy in the 21st century, but also how relevant that law and policy remains despite all of the extraordinary changes that have occurred in our technological age. And so, with that in mind, and without further ado, I'd like to introduce you to Robert Brain, clinical professor of law at Loyola Law School, who is going to lead us through the world of Warcraft. And I'm going to make Robert the co-host so that he can share with us his PowerPoints.
Okay, it's successful. All right, there we go. All right, one last thing on my end. Okay, there we go. So, hi, whoops, hello. There we go. All right, hi, everybody, and thanks for the opportunity. So it's my premise that there's a certain class of contracts that are going to be regulated worldwide, driven by the EU. And that class of contracts is multinational corporations in the digital space who directly contract with consumers. And that's a pretty big swath. That's Apple, that's Facebook, that's Google, and it is the video game companies too, as I'll show you. The video game industry is one of my research interests, you know, the famous shameless self-promotion. I have a case book in the video game law. And the video game industry drove one of the big EU laws. It wasn't the main driver, but it was a driver of it. And I'll show you how that has had worldwide effects. And then I also want to show you what's coming and explain why I think that the EU is the regulatory entity to pay attention to. Now, of course, if the EU regulates something, that doesn't mean the contracts in the United States have to reflect that. But that is, and in the digital space, people try and restrict. There was an initial effort to try and restrict, whatever regulation applied to just this area through geofencing. But geofencing, especially with savvy video game users, didn't work. It doesn't work very effectively. And of course, there's an economy to having one form of agreement worldwide. And if you have that, then you're going to, by definition, have to follow the most stringent requirements. And that's what has happened. And as I said, I think I'll show you what my prediction is, what will happen. So let me tell you a little bit about the EU right now. Post-Brexit, there's 27 member states. And this is one of the reasons we got to pay attention to the EU. The population is about 446 million, so it's about 100 to 110 million more than the US. And the GDP is, within shouting distance of the US, about 18 trillion, where the US is pegged between 20 and 21 million usually. So it is a big economic entity, and if it regulates something, then at least it has some global ramifications just because of its size. Now, I can talk for a long time about EU legislation, but let me tell you the two things I'm going to focus on for this talk. The big hammer for the EU are regulations, and those are things that are binding on all member states, and they have to get, there's a complicated way they get passed, but it's essentially Congress passing the law. And then there are directives, and the directives are not aspirational. They have some force of law, but the governing body of the EU might say something like everybody has to have a digital privacy statute, and the states or the members are given 3 years usually to pass their own national regulations on that, and then there's a review period. And if it's found wanting, if the protection of digital privacy isn't enough, then it becomes a regulation, and it becomes binding on everyone. Now, one of the driving forces of the EU is a protection for human rights, and the EU reads human rights very broadly. We might think of it as something like, innocence and jailing or torture or something like that. And of course, it encompasses that. But in the EU, it is also specifically in subsequent legislation includes privacy, including digital privacy. It even includes transparency, and in the legislation that's to come, it even includes how companies market to consumers is a human right, is a fundamental right, at least with the EU. Now, as I said, the video game space is kind of one of my interests. I'm a member of the Video Game Bar Association, and there really is such a thing. So let me tell you a little bit how the video game industry works and its part in my story here. So game developers are more than producers of a movie. They actually develop the game, they produce the game, if you will, but then they also control the distribution of the game themselves. And they have business to consumer agreements. And I've listed here some of the big multinational video game companies. And it used to be you had 3 or 4 different agreements with the developer. You had the end user license agreements, you had terms of use, terms of service, privacy agreements, and all of that. They're incorporated today pretty much into a solitary user agreement. And even those companies that still have a couple of agreements, they cross-reference each other. So there's an effect unitary agreement. And the one big piece of legislation that you probably have heard of, the GDPR, the General Data Protection Regulations, the one I'm going to talk about first, and it affects the privacy protections in the developer consumer contracts. Now, video games, I said, were a driver of the GDPR, and let me kind of set the stage a little bit. This was actually halfway through 2020. At the end, if you haven't kept tabs on the video game industry, you might be surprised. No, it's 180, to 185 billion industry worldwide in terms of revenue. So all the figures here are really up by about 1 billion because the video game industry thrived during COVID. Everybody stayed home and played video games. They didn't go to movies, so they were the beneficiary of COVID. And so, the European Union count is it's a $34–35 billion industry. So again, there's a reason for the EU to care about it. But you might look at a chart like this and said, well, Bob, if China made a regulation, wouldn't all the video game companies have to fall in line for that? It's a bigger economic entity. How about if the United States did it? And of course, that's true, but they haven't. China is mostly concerned with gameplay. China has regulated, for example, the Ministry of Culture says you cannot have a game played in China where you show dead people or pooled blood. China and South Korea are very interested in, especially minors playing video games, and there are things like Cinderella laws. They call them. Minors can't play after midnight, or you can't play more than a few hours in a row. So the Asian market does regulate games, and developers have to develop a new game for that market, but they don't develop the agreements, excuse me, they don't regulate the agreements between the developers and the consumer. And the US could, of course, but it hasn't. It's nationally, it's more concerned with excuse me, things like antitrust issues with respect to the video game industry. And so it is either, if you want to say it's left to the EU, or I would say the EU has shouldered its way to the forefront of regulating developer to consumer contracts based on its requirement, based on its charter that human rights, fundamental rights are central to becoming a member of the EU. Now, another reason why the EU, that the video game industry was a driver of the privacy industry, you can see it affects 391 million what they call active players, meaning people who play at least once a week in the EU, and it's close to 85% of the population. So you had something that affects a large amount of the populace as a big economic driver, and there were a couple other reasons too. Video games collect a truckload of data. Now, of course, so does Google and so does Facebook. And that's why I'm saying it was all video game driven. But Activision Blizzard says it collects more than 40 terabytes of information per day on its users. And of course, it's not the only developer. It's gone up as high as 50 terabytes, they've reported. Now, some of that's personal, names, addresses, credit card numbers, that sort of stuff. And for a long time, the industry said, well, the rest of it, the bulk of it is just telemetry. It is things like how many players can't make it from level 450 to 451 in World of Warcraft, and if too many people are getting stuck, we might tweak it, make it easier, or if a player can get in a corner of a room and can't move, and we'll fix that kind of stuff. And the industry said, we can't change that. We can't tweak individual information from that. It's all aggregate data. But that turned out not to be true. The video game industry is like any other industry. They collect data, they sell it to third parties. There are even third parties who come in and consult on how the game you receive are different than the game that Michael receives based on the probability of you buying stuff inside the game. So once that came out, there was another concern that there was all this data being collected in video game, being used in ways that consumers didn't appreciate, and so that was another reason for the GDPR. Now, one of the, I'm going to get to what the GDPR did in just a second, but one of the things it allowed you to do was get the information that they had on you. And just as an example of the kind of information, my research assistant's boyfriend is a big gamer, and so we asked about him. And we got 90,000 words. We got just from World of Warcraft, just from Activision. And I'm not going to obviously go through all this, but one thing I want to show you is that it's where you log in, right? They know that. And we have pages and pages and pages of this stuff that they do collect. So that was a concern. And then video games had one last thing that was a driver of the GDPR, and that's kids. Studies show that between 80 and 90% of minors between 6 and 18 are active gamers, once a week gamers at least. 50%, maybe a little bit more, play daily. And even a more concern is that depending on which study and how you define it, there is some incidence anyway of an addiction to video game play among minors. And in a way that baffles many, the United States isn't as concerned about addiction of video games, and certainly not addiction in minors nearly as much as the Asian and EU markets. And this is a top, I clipped the top of a report, just to, the report's 400 pages, but just to show you, even as back as 2008, the commission, which is kind of the executive body of the EU, was writing to everyone about on the protection of consumers, in particular minors, with respect to video games. So all this was kind of set up saying, we have to get a handle on digital privacy. We have a mandate to do that. And, we want to rein in not only Google and Facebook, but also video games. So GDPR was passed in 2016, came effective, it was a 2-year run up. And like I said, it replaced the data protective directive. So the directive was found wanting, and it became a regulation. And in between 2016, 2018, at every video game bar association meeting, there was at least one presentation, if not several, as to what are we going to do about the GDPR and how are we going to handle it. Now, the GDPR is, again, 400 pages, could take forever, but this is kind of the gist of it. All right, so it said that every consumer of any digital where there's in the digital space has a right to be informed about what's being collected. You have a right to access to it. That's how we got that of my research assistant boyfriend stuff. You have a right to correct anything that's wrong. You have the right to tell them to not, erase everything that you have on me. You have a right to restrict in the future what they collect from you, from nothing to you can collect telemetry, but not personal information. There's portability. There's the right to object to, what's the idea of the collection. And, this last one is, they can't make profiles to sell to third parties. Well, so what was now, before I get to the next slide, the violations, the EU wasn't messing around, and they said that we can enforce violations of this up to 20 million euros or 4% of your global annual revenue. Now, so what happened? Well, some games ceased to exist. Technologically, they could not do what the GDPR required. They couldn't just cut out Europe. That's Ragnarok. I never can pronounce it, Ragnarok, I think. Online, I tried to do that. It failed. So a lot of games ceased to exist because of the EU's regulation. But the biggest effect is agreements were changed, and I'm not going to go through all this, but this is what the Blizzard agreement looked like before GDPR, and it's what it looked like afterward. And you can see it just looks cleaner. And if you go up here, there's some gobbledygook, right? Prior to publication, in accordance with the applicable Blizzard terms of use agreement, and there's none of that in the new stuff. So agreements were changed worldwide because of the GDPR to come into compliance. This June, something that had been rumored for a while, but hadn't happened, but it did, is the EU passed something called the standard contractual clauses, and said that, we're still not satisfied with how companies are implementing the GDPR. And so here is a list of standard contractual clauses that must be in every agreement. Now, it isn't word for word, it's conceptual, but nevertheless, it's saying this has got to be in our agreements, and if it does, then again, it's going to be worldwide. Practices were changed. There was a flurry of activity. I don't know if you remember it, but not just video games, but Google and Facebook and United Airlines and Jimmy Choo and lots of people changed their agreement. You probably got an email that said we are changing our privacy agreement between the end of 2018 and the beginning of 2019. And they did that because of the GDPR, and you probably didn't pay much attention to it. They change it all the time, but it happens. And the EU is showing that the finding thing wasn't just rattling the sword, they brought all these fines. So we have an example of how a regulation of the EU has had worldwide effects. And let me tell you kind of what's coming, and then I will be done. There are 3 proposed pieces of legislation. I'm only going to talk about one in any detail, and only the second one I'll just mention because they're kind of a couple interesting things. But this is the one that has most digital platforms worried. And this isn't going to be so much the video game industry. But, again, the same sort of pattern. There's an e-commerce directive, it's found wanting, they're going to make it a regulation. And so it's going to apply to platforms having more than 45 million users worldwide, or 10% of the EU's population. And so it'll include the companies I have there. And what it really is doing is taking on Section 230 immunity under the Federal Communications Act for platforms that tend not to be publishers, but nevertheless regulate content. And so it's going to require that you publish your at least the parameters, if not the actual algorithms used for content moderation. It's going to publish annual reports, require publication annual reports describing what was removed. There has to be a more streamlined and user-friendly complaint procedure. And if your investigation as a platform shows that it wasn't illegal or it doesn't violate your terms of service, you have to reinstate it. And now, having had so much fun with 4% of global revenue, the fines can go up to 10% of global annual revenue. The other thing, the one I'm going to talk about only briefly, is the Digital Markets Act, which is same kind of companies. And they're going to say first, it says you're going to have to allow side loading, which means that you can't just buy Apple's apps from the Apple Store. You're going to have to allow third parties to sell them. They side loading. It's kind of an industry term. And no self-preferencing, for example, that if you type in batteries in Amazon, you can't get Amazon Basic. It comes up on the first page every time for batteries. So again, my premise is that there are certain sector of contracts in the 21st century, multinational corporations, digital space, and direct-to-consumer agreements that are going to be regulated by the EU because no one else is stepping up. And the EU takes that role seriously and based on part of its charter. And so I think that's an interesting development in the 21st century, and why I was happy that Michael gave me the chance to let you know about it. Thanks.
Thank you, Robert. Appreciate very much not only the talk, but the ominous implications of what's going on there. So our next speaker is, I'm going to co-host him right now so he can start to set up his presentation. Our next speaker is Professor Dan Croxall, who's Associate Professor of Lawyering Skills here at Pacific McGeorge, and has in fact been one of the shapers and developers of this specialized area of brewery and beer law, which is an interesting sort of complex of different areas of law and policy as they affect this kind of industry. And he is going to talk to us about some of the important contract implications of the craft beer industry. Dan, I hand it over to you.
Thank you very much, Michael. And thank you for being here and letting me introduce you to my kind of weird and fun little world. As Michael said, beer law, wine law has been around for a while. Beer law is relatively new since, about 2010. Well, not beer law overall, but craft beer law. And it really is a lab for highly regulated industries and then how government regulations can impact that. So I'm going to really point you towards one of the biggest issues in craft beer law today, and that is distribution contracts. They are a unique area that I think you'll find interesting being contract scholar. So just really briefly, the reason that I do this kind of law is prior to coming to academia, I used to represent independent craft breweries for a career. My brother owns one in LA, and that's how I got into it. Now, the interesting thing about beer law is starts with America's weird relationship with alcohol. We have our own structure that's very different from every other country in the world. I guess there's some similarity with England in terms of tied house laws, which we'll talk about briefly, but it's this strange environment that stems from prohibition, right? It started in this weird area, connections between women's suffrage and temperance, and disparate groups advocating against alcohol as a legal item in the United States. Different groups such as I mentioned, women's suffrage on one hand and the Klan on the other, advocating for full temperance. So there's a storied history there, but what has come out of that is a very disconnected version of regulatory theory here. In the United States, every state has its own regulatory strategy and structure. We can generalize a little bit and call it a three-tier system. So the first tier is the manufacturer, the brewer, the winemaker, the distiller. The second tier is the distributor or the wholesaler. You can call them either. And the third tier is the retailer. And the idea is we want to keep those three tiers completely separate so that one can't unduly influence another. And this stems from the old saloon concept from the 1800s, where a manufacturer might own a saloon, and then they would just push that product, selling it to whoever they can, as much as they can, temperance be damned. And so the idea is we don't want retailers to have undue influence, manufacturers to have undue influence over retailers or wholesalers to push only that one product. So they have to be kept separately according to the three-tier system, free from any undue influence. I'm going to focus on California here. As I mentioned, each state has its own version of this law, but we're going to look at California as an example. So California, interestingly, and many other states, is really a modified two-tier system, because if you're a craft brewery, you can distribute your own beer directly to the consumer. You can sell it out of your tap room. And that's what most breweries want to do, because when you get a distributor involved, they take about 30% off the top for each packaged item. That's how distributors make their money, is they take that 30% cut, the brewer loses out on that. And so most breweries want to avoid distribution, but it has a very important role to play, because once you hit about 5,000 barrels, which a barrel is 2 kegs, and if you're self-distributing, you essentially become a trucking company, and you have to have dispatch, and you have to have drivers and all those things. So it's a big headache. So that's kind of where distributors come in. Other states mandate that you use a distributor. So again, that varies. But I'm going to give you some of the highlights about what makes distribution contracts unique. If you were to look in California, you would find them in the Business and Professions Code, the Alcoholic Beverage Control Act, in the 23,000 section. Most lawyers have never been that far into the Business and Professions Code, but that's where we find these laws. Okay, before I tell you about the 4 specific types of law I want to mention about contracts, there are 2 types of states that I want you to be aware of. We have what are called licensed states, which are what we have in California. You're either a brewer, type 23, a distributor, type 17 license, or a retailer, which is various different types of licenses. Other states like Colorado, for example, are what we call control states, where the government actually monopolizes one segment of the 3 tiers. Okay, so a distributor could be owned by the state of Colorado. Colorado, in fact, actually has the retailers until very, very recently were owned by the state. And Utah used to be similar that way as well. So a little bit of background. Most states use the license model, where if you want to participate in any of the tiers, you go get your license. Other states are more restrictive, and the government maintains a monopoly there. Okay, so here I'm going to jump into a little bit about these particular 4 areas of contract law. Okay, so right after Prohibition, distributors had a fairly strong lobbying group behind them, nationally and at the state level. And their qualm was that manufacturers, at the time, there was only about 8 beer manufacturers in the country, right? You can think of the big ones, the big brands that you've heard about. And the distributors were the small companies that were out trying to move that product for the big breweries. And those breweries thus had all of the power. They would hire a distributor. They didn't like what the distributor was doing after a week, they'd fire him and they'd go get someone else. And they just would quickly move through various distributors. And of course, to take on a new brand, a distributor has to put in money and time, and it's an expensive endeavor to take on a new brand. So these small wholesalers were essentially getting treated poorly. And they were able to lobby the states and under the Federal Alcohol Administration Act to garner themselves power to create a power balance between the brewers and the wholesalers. Now, my thesis is that those reasons for that power balance I'm about to talk about no longer exist today because the market's flipped. There are far more brewers than there are distributors. In fact, in California, there's one distributor that this year is going to distribute 73% of all the beer in the state of California. So as you can see, the reasons for extra powers or extra protections for distributors no longer apply, but the laws are still in the books. So what we have, I'm going to skip this. Here we go. The balancing of power. What did I mean by legislative balancing of power in the contracts world? It's these four things. In most states, a distributor has territorial protections, meaning exclusivity. And this is in the Business and Professions Code or the Alcoholic Beverage Control Act of the given state, meaning if a brewer and a distributor enter into a contract, that distributor has the exclusive right to distribute within that territory. And that's mandated. You can't have a distribution agreement in most states unless it's exclusive. Another one is transfer protections. So again, through the Business and Professions Code, the legislature, a distributor can freely sell the right to distribute a particular brewery's products to another distributor without the consent of the brewer. And so it's almost like the insurance market. You know, when you sign up for Farmers Insurance and then later you get a bill from World One Life, you didn't sign up with them, but there's that whole insurance market. Very similar with distribution contracts. So distributor A might want to get rid of a particular brewery for whatever reason. They can then sell those rights to distributor B without the consent of the brewer. The only restriction is that you can't unreasonably withhold your consent. And good luck litigating that, because again, the wholesalers have the power and the size, and the small breweries, if they're going to try to withhold their consent, there's going to be a lawsuit. And who can afford that? Not the brewery. Termination protections is the most important. This is the good cause, which we'll talk about. So I'm going to save that, but the shorthand version is a brewer cannot get out of a distribution contract once they sign it, unless they can satisfy what we call statutorily defined good cause. Usually that means bankruptcy, fraud, or other illegal conduct. It doesn't mean the distributor is doing a bad job. And lastly, dispute resolution protections. You can guess what that is. Most states require, some require an arbitration first, and some require jurisdiction only within the state where the contract is executed. So you couldn't file, for example, in federal court. So let's talk quickly about territorial protections. Almost all states require exclusivity. In California, for example, if you want to sell your distribution rights to a distributor, it has to be by county or by particularly described area. You could use, like I said, counties, you could use city, you could use varying streets in a particular area. But once you sign that contract, you can no longer distribute your own beer in that area, and nobody else can either. So it really is kind of a marriage in that way. This is an example of what the statutory language looks like. It's kind of old timey, as you can see, but you know, every beer manufacturer who sells or distributes beer in this state shall designate territorial limits in the state, right? So exclusivity. So that's really, really, really tough, because what if it is, I'm dealing with this right now for a former client. What if a distributor is not paying attention to your brand? What if they have a new love that they're pushing that person's brand to kind of, you know, damage to your brand? Well, you can't go out and sell your own beer because you have this exclusivity problem. So you have to engage in notice and cure type breach of contract discussions, which are seldom fruitful. As I mentioned, the transfer protections. Most states limit brewers' ability to object to a transfer. Now, one thing you should know is that in the distribution world, you're called either a blue house or a red house. Red house are the distributors who tend to sell Budweiser, AB InBev products. Blue house is Miller Coors. Okay, most craft breweries don't really want to be on either because those companies make that 30% in large scale off the big breweries, off the big breweries. So the Budweisers, the Miller Coorses, right? So they don't have a lot of room for the little small independent mom and pops. So what happens then is now that consolidation is occurring so strongly in the market, these distributors are buying up small brands, but their loyalty is elsewhere. And so we're seeing a lot of small independent breweries struggling to get their beer on shelves because the distributors don't have the incentive to do it because they make so much more with the big house. Okay. And again, these are laws that are on the books, lobbied for and supported by the wholesalers across the country to give them this balance of power that was allegedly so necessary. Now, here's this unreasonable language. Sorry about that. I mentioned that the only way to object to a transfer of your distribution rights, if you're a brewery, is to reasonably withhold your consent. I've seen that happen a couple of times, and each time it's cost the independent brewery dearly because the wholesaler will go out and hire a big law firm, and they will, start discovery, file the lawsuit, et cetera. And the damages that can be achieved are too high for most small breweries to suffer, right? Recoverable damages shall not exceed compensatory damages sustained by the wholesaler and the wholesaler's costs of suit. Okay, so we have costs there too. Fair market value of the beer wholesaler's business is not limited to goodwill. All these things add up. So you get these multi-million-dollar lawsuits where the brewery that's got operating capital of $500,000. So the transfer protections is a very strong balance of power that wholesalers own. Here's the most important one: termination. What happens when the distributor is doing a lousy job and they are not moving your product, they are not giving your product the time of day, they've decided that it's just not a movable beer? Well, most states have a statutorily defined version of good cause. And in most states, that includes, as I said, bankruptcy, fraud, or other illegal conduct. If you can't show those things, you can't get out of a distribution contract for breach. California has a slightly different version. California doesn't define good cause, but it specifically says in the statute that the distributor's failure to meet a sales goal or quota that is not commercially reasonable under the prevailing market conditions. How are you going to prove that? Okay, why would you hire a distributor if you're a brewery? You want the distributor to move product, right? They make money doing it. That's how you make your money. If they do a lousy job, California has enacted this law that says, sorry if they're doing a lousy job, okay, they're not moving enough of your product, you have no remedy. There's no breach. You can see how that'd be very problematic for the small company that needs to get out of the contract, but can't because of these termination protections. So you can see the language from the statute here, again, is pretty old-timey. And notwithstanding the provisions of any agreement for the sale or distribution of beer between a beer manufacturer and beer wholesaler, no sale or distribution agreement shall be terminated solely for a beer wholesaler's failure to meet a sales goal or quota that is not commercially reasonable. I've had a couple of clients who were able to get out of these. The big problem there is, what is commercially reasonable? The distributor is going to have all these facts and data and statistics and market studies, and the independent brewery doesn't have access to that kind of sophistication. It's obviously a one-sided fight. And then really quickly, lastly, is the dispute resolutions. Most states have mandatory venue requirements. So if I'm a brewer here in California and I sign up in Virginia and they're going to start moving my product and we have a dispute, I'm going to have to litigate that in Virginia, not California. And we're not going to be able to do it in federal court either. So, these things tend to help the distributors discourage breweries from trying to file suit unless it's within the local venue. So you can see these four types of powers. The wholesalers at the time, I suppose, were being taken advantage of by the big players. But again, those times are changed. It's completely flipped. So I want to leave you with a story. Where is? I think it's late. Oh yeah, okay, here it is. In 2008, AB InBev had this program called 100% Share of Mind. There it is. 100% share of mind. So AB InBev has its own distributors. There are distributors that are associated with AB InBev. That's Budweiser, and that means they really put their focus on these small companies. Okay, so increasing pressure on the distributor to only move the big guys, right? So what AB InBev did was, this is from the National Beer Wholesalers Conference in Vegas. Each of you must exert your undivided and total efforts to Anheuser-Busch products. If you sell our competitors' products, can you still give us your best efforts? I don't think so. You can see the pressure if you're a distributor, right? Budweiser moves large volumes. You're going to want to be more loyal to them because that's where you're making your money. And so they started a new program where they were giving monetary incentives to distributors who met certain goals. If you sell X amount of Budweiser products, we'll give you cash. Now, that is problematic under the 3-tier system, but it's a little beyond the topic we're talking about. So this was an incentive program that AB did. The numbers were this. You could get $1.5 million if you're an independent distributor if 98% of the beer that you sell came from AB InBev. If it was 95%, they were up to half of their marketing costs was a benefit that AB would give them. So what's the point of this? Small independent breweries cannot play the game, right? Unless you're going to self-distribute. There's no way that under the current status of the law, with all of these powerful legislative balancing provisions, there's no way that independent craft beer breweries can compete in that market, which is why you're starting to see less and less independent breweries at things like chain restaurants and things like grocery stores. And it's getting harder to find because of the increasing pressure on that the distributors are putting on the independent craft breweries. I will tell you, the one way out, the going market rate, you can buy your distribution rights back under most states if you're unhappy with the distributor, but it's 3 times annual gross. I don't know many craft breweries that are able to just fork over 3 times annual gross for that particular distributor's production of the prior year. So if you, again, if they sold $100,000 worth of your product and you want to buy your way out, the market rate would be $300,000. Very, very few breweries can afford that. Okay, thank you very much for your attention and your time. I hope that that felt a little weird to you. It should have, because I don't understand how these legislative protections are still on the books. I find it part of my obligation, given this is my area, to make it more public and perhaps have the law changed in the relatively near future. Thank you.
Thank you very much, Dan. I guess this shows us just how freedom of contract leads to an extraordinary lack of freedom. But that's the way it goes.
Absolutely. And an interesting thing is compelled speech. Is this the government telling us what we have to have in our contracts? But that's another law review article.
There you are. Hopefully, I assume that this is all much better in the new economy. And in order to explore that issue, we have Kate Vitasek, who is the a part of the graduate and executive education faculty at Halsam College of Business Administration at the University of Tennessee. And Kate has been doing, over now a considerable period of time, just an extraordinary range of scholarly inquiry and analysis on what is happening to contract and contract principles in what we so easily refer to as the new economy. And she's going to share some of that with us now. Thank you very much, Kate. And you are now the co-host, and feel free to share your slides.
Excellent. I am sharing my slides now. Can you see that?
Yes.
Fantastic. Well, thank you, everyone. And Michael, thanks for having me join. I'm kind of a odd duck in your KCon conference because I'm not a lawyer. I'm not a law school professor. I'm a supply chain professor. So I really come at it from the buying and selling business angle and kind of stumbled into contracts through our research. So I want you to keep that in mind as I share our perspective, because it is from a very business perspective and an economics perspective. So let's talk about the new economy and how contracts can adapt and why they need to adapt. So let's first start with looking at what is this new economy? And I would say that it's not really new, that it's been evolving for years. It's more outsourced than ever before. We're more global than ever before. And those two things really started to rise in the 1990s. And now front and center, we have a lot of volatility and risk with geopolitical pandemics, fires, different things. It makes our supply chains very unpredictable. And that's tough if you're a company trying to manage your supply chain and working with these outsourced global types of suppliers that you have. Also, our consumers are more demanding than ever. They're agile, they want agility, they want flexibility. They're used to Amazon. You hit the button and you get free shipping. So companies are trying to upskill to see how they can work to create value. Instead of just buying and selling, value exchange, how can I actually collaborate to create value? So you'll start to see things like value creation. And that manifests itself into a variety of types of contracts. For example, in Australia, they have what is a very popular trend called alliance contracting. And so how do we create these more strategic partnerships that we are transparent and can create value? And lastly, we have new technology that makes it interesting. Cloud computing, AI, that gets into your GDPR clauses and stuff that we learned about earlier. And so if I just pull some Amazon headlines, this is, if I'm a business person, this is what I'm hit with. Global, outsourced, agile, value creation, risk, And so as business people, we're trying to keep up with all these changes. And my thinking is, business has changed, but our contracts haven't. And I just want to throw out one little statistic here. There's lots and lots of statistics to support the lean, agile, AI, all kinds. You can look at and pull, just do a simple Google search and see statistics. But I particularly like this one graph here that I wanted to highlight. And this is just services. So if you think about outsourcing and services, in the past, the companies were more vertically integrated. So they controlled their supply chain more, right? And so now look at it. If you look from 1994 to 2015, the percent of services, and in particularly complex services, IT, logistics, facilities management, business process outsourcing, right? We are growing and using more service-based contracts. And I got into this in 2003 when the United States Air Force and Department of Defense asked the University of Tennessee to study what they called service acquisition contracts. And I wasn't looking at it from a contracting perspective. Again, I was looking at it from a supply chain perspective. They had all these services that they were trying to acquire, IT deals, logistics, maintenance deals. For example, they have the 404 GE engine maintenance. And GE sells the contract and they need maintenance on this. Who best but to provide the maintenance than GE? Well, that's a $10 billion contract. So these are very big, very complex types of contracts. And you're seeing more and more of that shift to services, which are harder to find. It's harder to write a contract for a service and something intangible than a widget. And so in 2015, we began to think about, well, how as a sourcing person can you deal with all this complexity and change? And can we rethink kind of the toolkits that procurement people have? And we wrote the book, Strategic Sourcing in the New Economy. Bonnie Keith, one of our co-authors, a former chief procurement officer for PepsiCo and ABB. So we kind of had a practitioner bend and an academic spin to this. It was really a book written for practitioners, for strategic sourcing and procurement folks. And this book has been adopted by Sourcing Industry Group, the Dutch Association for Purchasing Management. And it really started, the goal was to teach people, you're living in a more complex world. You have to slow down, and not everything's a commodity. You can't treat everything like a widget and have these transactional ways of working. So when you have more dependency, when you have more risk, you need to shift to be more transparent and strategic with these suppliers so that you can look at the root causes together and improve your supply chain. And so kind of the tagline here is that if we're going to work with supply chain partners, right, why are we adversaries? So when we get to our contracts, why are we like us versus them, you know, buy, sell? Wouldn't we have more collaborative ways of working, not just through the procurement process, but also for the contracting process? And one of the things that we heard from the business people is they absolutely disliked their lawyers. They would come up with great things that they could do, and then the lawyers would get involved. I know, Matt, it's sad, right? But I laugh because this wasn't a new revolution. It's happened for decades. And actually, the more that I started to think about contracts, you go back to the 1960s with Stuart Macaulay and Ian McNeill. You know, Macaulay's articles, one of the most cited articles in the history of law schools articles and legal journals. And his premises was businesses, you know, businesses like contracts, business people don't. So fast forward to the 21st century, the same thing. So how could we have this debate for 70 years and still not have solved it? And that's what we would find when we would go into these businesses on these complex deals. They're pulling their hair out. And so we really looked at, well, how could I solve this root cause, right? How could I help teach? And again, we're focusing on the business people. And so we turned to Oliver Williamson's Nobel Prize winning work on transaction cost economics. And so the theory behind transactional cost economics is if we can improve how we work, we can lower our transaction costs. Let me just give you one little statistic here from a recent deal. There was a very large high-tech company that just did a facilities management outsourcing, and they've been outsourcing for over a decade. And this contract needed to be renewed, so they did a big bid. The suppliers, there were 3 finalist suppliers. Each one spent over $1 million on the bid. Transaction cost economics. So we're as a buyer, we're injecting these things that actually are raising our costs and making it hard, right? And so if we think about, well, how can I make my relationships with my suppliers easier? How can I reduce the friction? How can I reduce the transaction cost? Not just through the buying process, but the contracting process and post-contract. So from a supply chain perspective, we want to look at that process. So what Oliver Williamson says is, you know, you can either make or buy. That's the traditional way to look at it. And when we work with business people, sourcing people, it's all about make, buy, make or buy, make or buy. If I'm going to make, Oliver would say it's a corporate hierarchy, right? Vertical integrated. And if I'm going to buy, he'd call it using the market. And his work says that there's a whole playground in the middle. And he called this playground a hybrid. There's something in the middle. You don't want to just be arm's length, you know, buy, sell, adversarial with your contracts. Everything's a commodity. He said, you got to really think about it more strategically and work to reduce that friction, which will drive down your transaction cost. So we started to look from a sourcing perspective at the ways companies were buying and selling. And we broke it down into 7 models. So there could be more than these, but they kind of, all of them fall into one of these. For example, in Australia, you have the alliance partnerships. The Department of Defense does public-private partnerships. Those would be what we would classify as performance-based contracts. And so there's these 7 types of classifications of the guts of how buyers work with suppliers. And they range from transactional, which is using the market. You go to Amazon, you click the button, you're simply using the market. And buyers have very sophisticated ways to do this. They have Ariba, these online catalogs. And then I start to get contracts involved. It may just be a simple PO with an approved provider, but then I'm getting a master services agreement. And then I'm going to have service level agreements under these more performance-based or managed services deals. I may have shared risk, shared reward under the vested type models, these alliance partnerships. But I could also have investment where the buyer says, you know what, this is so important to me. I don't want to buy, I want to make. Or it's so important, I'm just going to acquire you. So a joint venture or a subsidiary. So here's our continuum and the different ways that buyers are meeting their supply needs. And in here in this middle, you'll notice at the top, we have a term here, relational. And this is because as you get to these more complex type deals, these more risky deals, variability hits in, dependencies more important. And as we get to this dependency, we need to focus on the relationship. And that's what Stuart Macaulay found back in the 1960s. That's what Ian McNeil found, right? Is the relationship matters. And so why are we putting the contracts in a drawer? And I've always thought that was really bizarre as a business professor. Why do we say success is I put the contract in a drawer and I never pull it out? Well, what we contracted for today is not going to be what we need in 6 months or a year. So we have this disconnect between what business people want and what they buy. And it actually creates this tension. And so we need to have our contracts aligned to the business needs versus anchoring them down. And so the relationships are very important. And the more we started to work in this area, the more lawyers started to literally like what we were doing, applying some of our concepts, our methodologies. And so we teamed with, I'm the only non-lawyer on this book. This is our latest book. It just came out. It's called Contracting in the New Economy. And it was, well, how do we actually tackle this process all the way down to the contracts piece of that? And so the theory here is that contracting in the new economy demands a new approach. So if business needs more flexibility, agility, it's more outsourced, it's more volatile, we need contracts that are going to embrace those changes rather than anchor us down into these very transactional ways. Now, ICCM, now World Commerce and Contracting, has done some work, and they estimate that 98% of all contracts are transactional in nature. So it's very much buy, sell. Here's your widget, here's my money, right? And we need to be shifting to these more dynamic ways of working, these flexible ways of embracing business change. So we call this the contracting paradox. And it's really a delusion, because we write contracts to make plans. We want to, have a certainty and security with our suppliers, but we can't actually plan very well because business is dynamic. So the plan's always changing, but our contract's static. So we trick ourselves into believing that we can plan and we can write these plans. This is an actual contract from the Department of Defense. This is an Air Force contract. Seriously, who's going to read that? And so it's never been so important to plan, but it's harder than than it has ever been in the past. And we think we can do a perfect job of a contract, but we can't. And then no one wants to read it. You put it in a drawer. And so this fact has been researched by the psychologists, not directly related to contracts, but related to economics, behavioral economics. And people tend to oversimplify reality. Oh, I know that. I can write a clause for that. Oh, we can come up with that. Oh, that risk may happen. And so I have to write this really strict clause so it can never happen to me and I can never get hurt. And that's how we end up with these contracts that business people just really hate working with their lawyers. And so our philosophy is, why is that? Can't we have harmony here? Because when we have harmony, we reduce our friction. So our premise is that we need a different lens, and that lawyers and business people need to come together, and we need to write flexible contracts that are based on reality. And the fact is, business is risky. Suck it up and figure out how to share risk and share reward rather than writing a clause that's going to protect you. Because if I write the perfect clause to protect me, the supplier is going to fight back. And that cost, again, that's the friction that we get, the transaction cost economics. So let's be very transparent and try to solve. If we can be transparent and work together, we can mitigate some of these risks, right? Embrace the fact that business is dynamic. Instead of having a penalty because your shipment was late, because there's a staff shortage or ships are stuck in the canal, embrace the fact and try to solve, how do we get to root cause? How do we work together? And so there's a lot of research that supports the concept of a flexible relational contract. I've mentioned Stuart McCulley, Ian McNeil, Oliver Williamson. More recently, Gillian Hadfield has a wonderful book on the concept of scaffolding, and Oliver Hart's work. We've been teaming with Oliver Hart. He won a Nobel Prize in 2016 for his work on contract theory, and he's become a big fan of our work. He actually wrote the foreword for a new book. And so our premise is we need to have more relational contracts. But when I look at the history of relational contracts, there's this faction between having complete formal original contracts and relational handshake deals. So a lot of people think that a relational contract is outside of the contract. It's the handshake, and they're afraid to do it. I hear this all the time in our work. We can't do that. That won't uphold in court. That's craziness. You know, this that's soft, stuffy, fluffy stuff. We want it to be hard. We want it to be the big fat contract. So in our Harvard Business Review article a couple years ago, we really put a hard premise down that said you need to have a formal relational contract, which is a legally enforceable written contract. So the relationship stuff is in the contract. It should be enforceable. It establishes the commercial partnership. And I use the word partnership lightly. It's not a legal partnership, but it's a commercial relationship that's flexible, because business is flexible. We embrace social norms because we know from behavioral economics that social norms, when upheld, create lower transaction costs. So we should be embracing the concept of good faith and putting lots more words around what is good faith and how do we make decisions that are good faith. Instead of leaving this like simple little one-word sentence thing said good faith, tell the business people what it means and how to solve your problems. So not just having a dispute clause, but having an entire governance structure, an entire roadmap, give the business people a flow chart. Here's how you get unstuck. Give them standing neutrals to help them early in the process. And so this way, our contracts are always in continual alignment. So I don't want to have business people being afraid of the contract where the contract's stuck in a drawer and they get out of harmony and then they're in more disconnect that causes this pent up demand. So have the business people and the contract always be evaluating the dynamic nature of business and change their contract. So here, what we would say is this hybrid, to use Oliver Williamson's terms, is really a flexible contract framework. And to use Macaulay's words, it's an instrument for social cooperation designed to keep the parties in continual alignment. So why are we afraid to write the relational stuff in the contract? If that's what makes the businesses successful, put it in and make your contract the playbook. And write those contracts in plain language. So they're not someone who used, Robert, I think you used the word gobbledygook, right? And I think, Dan used the word old school or some old timey, right? Why do we have these old timey gobbledygook contracts? And there's a whole movement, not at the University of Tennessee, but I love it, on plain language and visualization, because your contract should be the playbook that business people can understand that contract and they can get unstuck. So we've had about 50 organizations do about 80 contracts using our methodology. And one of those is the Canadian government. They have 4 deals using our methodology. And one of those is Island Health in the hospitals. We featured this in the Harvard Business Review article. And these were their doctors. So think about it. The doctors, they're highly dependent. It's a labor services, it's outsourced services type of a deal. This was the headlines when they came to us. The CFO and head legal counsel came and said, we're stuck, we're in lawsuits, we hate our doctors, they hate us, and we cannot fire them because if we do, we have no doctors. They can't quit because if they do, they have to leave the city and go work in another Canadian province. So we have to figure this out, and we hear rumors, you've got a way to help us. So they went through our process that we outline in HBR and in the book, these 5 steps to bring the companies together. And so Glenn Gallons is a professor of law, but he also practices law. at the University of Victoria. And he talked about the co-creation. So what we do is we put a team of people, buyers and lawyers together, buyer, supplier, business people together with attorneys, and we have them think about the dimensions of their relationship, where they're going, the scope, the metrics, the money, and the governance, and the relationship. And they co-create the words of their contract in plain language. And the lawyers are there to listen to the business and translate it to make sure it is a legal contract. So now the business and the legal side are in harmony. And he says, look, taking that foundation of the relationship is brilliant because it puts the people in the room together and says, look, we got to solve this. It's not negotiating. We're not going to sit across and negotiate. We need to come up with a contract that is reality, that's based in reality, that helps us. And so when the pandemic hit, this was a great test to a formal relational contract, because look at the headlines post doing a relational contract. As the pandemic persists, BC rolls out hospitalist home program where they're innovating, they're working together, they're solving the dynamic nature of business versus going back and being adversarials, because they put the relationship first and the relational mechanisms. So all they have to do is pick up their contract and say, this is how we get unstuck. Here's our playbook, right? So the relational components are embedded into that. And then we track the satisfaction of these teams. And so look at May 2016, before they switched to a relational contract, a formal relational contract: distrustful, broken, dysfunctional, strained, untrusting, suspicious, right? Toxic. Ooh, that one's nasty. 2 years later, so after moving to a formal relationship, a relational contract, and they have now their playbook and their governance structures: collaborative, respectful, trust, cooperative, supportive. And now look at it in the height of the pandemic. This was just taken about a month ago. Collaborative, strong, respectful, trusting. They can now deal with the dynamic nature of business because their contract isn't about the billable line item and the compliance issues. It's about the billable line item, the compliance issues, and the relationship and how they solve problems. So with that, I want to leave you two statistics here. One is from Leslie Wilcox, London School of Economics. Trust-based contracts. He studied 1,200 trust-based contracts, and they showed a 40% difference in cost savings. We saw this with Island Health. Island Health actually, working collaboratively, beat the budget that they had, right? So we definitely see this lower cost through collaboration. We also see higher innovation through collaboration. Here's another one. John Hankey studied the automotive industry, and in particular Chrysler, and he's tracked for about 20 years supplier trust and the economics of the automotive industry. And the higher the supplier trust, the more innovation and cost profitability they have. And Chrysler was bought by Daimler. So they were mean and kind of adversarial. And then they decided to really build trusting relationships, be more Toyota-like. So you could see their innovation and profit go up. And then they were bought by Daimler. And then they went back to being adversarial. So he's tracked the supplier innovation and profitability to the supplier trust levels over 20 years. He estimates $24 billion in lost profit. So if trust and if collaboration and transparency create value, we've got to start embracing contracts that do that and embrace the relational components. So that's a little bit about our quirky research at the University of Tennessee from the business side of contracts.
Kate, thank you so much for that presentation. I've got to tell you, I'm sitting here thinking about how I have to start reworking my contracts class, just listening to what you had to say. And I think there's a lot to be learned from this. Thank you so much. We're going to have questions later on, but right now we're going to go to our last speaker, who I guess is me. And I'm going to talk to you about yet another feature of 21st century business and contracting, And this has to do, if I can figure out how to do this, this has to do with economic sanctions and contracts. You know, the use of economic sanctions is usually something that we think of as remote and not really something to be talked about, but it has become more of an issue for us. The use of economic sanctions, by which I mean, you know, government restrictions on economic activity of other nations, their officials, often their general population, that appears to be a prevalent feature of contemporary international politics and business. Unavoidably, sanctions may also have, as a result, a very significant effect on a contract party's rights and obligations. What I'm thinking is that particularly when you operate in a transnational context, which is more and more often the case, you cannot rest on the assumption that the imposition of sanctions is an extraordinary and unusual event that's unlikely to have an impact on your rights and obligations. That's not a safe assumption. I wanted to talk briefly just about the historical context. You know, as Kate pointed out, we've got all these modern trends and we're all moving forward, but the long shadow of history seems to affect us nonetheless. Economic sanctions may seem like a very modern device responsive to our intensely transnational environment, but in fact, its use has classical roots. At least as early as the 5th century BC, Pericles and his import embargo on Megaria, which, according to Thucydides, was one of the events prompting the Peloponnesian War. You know, how dare you bar us from your harbors and the like. And in our own legal tradition, economic sanctions have very deep common law roots, both in the United States and in Britain. Trading with at least a declared enemy state or its nationals was prohibited as a matter of common law. And indeed, traditionally, even private commercial interactions with people located in declared enemy states could often be viewed as treason. So in modern US practice, economic sanctions are almost exclusively a matter of legislative authority. We don't leave this to general common law anymore. Legislative authority and prohibitions, both in times of war, which was the traditional context, and also during periods of declared national emergency. The first modern statute in this regard was the Trading with the Enemy Act of 1917. Now, this statute was intended to authorize the president to impose sanctions on enemy nations, their allies and their nationals in wartime. But then, beginning in 1933, during wartime or a declared national emergency. Since 1977, post-Watergate, the use of the Trading with the Enemy Act has once again been limited exclusively to wartime for situations that might be critical, but without a declaration of war, and that's an increasingly common situation in our times. There's new statutory authority created for economic sanctions, and that is the International Emergency Economic Powers Act. So you have this nice, neat division between statutory authority during time of war, statutory authority during time of emergency, but not war. What's the difference? Well, the substantive powers are essentially the same. The big difference is that there is more active requirement for the president to consult and to report to the Congress about what he or she is doing. Whether that's anything more than a form, of course, I think begs the question, but we will leave it at that. Now, completing the range of basic sanctions authority in US statutory law, we also have the United Nations Participation Act. Section 5 of that authorizes the president to use powers other than the use of force to comply with any mandated requirement of the Security Council that sanctions be imposed. Now, that seems to be out of order. The United Nations Participation Act, 1945. Why do we put it last? Well, in terms of its active use, this is pretty much the order. Trading with the Enemy Act, a long-standing historical piece of legislation, which still has some utility today. The International Emergency Economic Powers Act, a constant source of presidential power throughout the post-war period following 1977. The UN Participation Act, because of the stratification of the Security Council, pretty much lay dormant for a while, and it may be that that is now actively beginning to change. So it would seem then you have a statutory framework for sanctions that assumes that declared war or something like, to use the language of the International Emergency Economic Powers Act, something like an unusual and extraordinary threat is the basis for the use of economic sanctions. Yet in recent times, sanctions have become something approaching a common feature of US international economic policy, affecting nations, their nationals, and related persons across all continents, except arguably Antarctica. Hence, the likely impact and effects of economic sanctions may be relatively more foreseeable today than they might have been a century ago, when the imposition of sanctions would genuinely have been an extraordinary event. So we need to talk about the prevalence of contemporary economic sanctions, because I think that has an important effect on contracts and our understanding of when contracts can be discharged. There is such a wide variety of sanctions in place, unilateral and multilateral, trade sanctions and financial, direct sanctions and indirect, where we go off and sanction middlemen rather than just our primary targets. There's such a wide array that sanctions now are almost a defining characteristic of contemporary international relations and business. As a result, it would be very misleading to view economic sanctions as unusual or emergency, rather than a commonplace feature of contracting in the transnational market. Now, the potential impact of economic sanctions is therefore an increasingly pervasive risk factor, which identifies sanctions-related actions undertaken by administrations. If you look, for example, just at the first 6 months of the Biden administration, there is considerable activity in the sanctions field. Just to give you some examples, adjustments that eliminated some sanctions with respect to the southern border, likewise as to immigration. But around the same time, you have a blocking of property with respect to the situation in Burma. Yes, the administration continues to call it Burma. That's up to them. Termination of an emergency with respect to the International Criminal Court, but roughly at the same time, the blocking of property with respect to harmful foreign activities by the Russian Federation government. All of this put in place. In addition to that, threats from securities investments that finance certain companies of the People's Republic of China, blocking of property and suspending of entry for certain persons contributing to the destabilization in Western Balkans. And coming back to some of the things that our previous speakers were talking about, sanctions imposed to protect American sensitive data from foreign adversaries, this use of IT as an active weapon. Within the first 6 months, you have all of this movement and activation of various sanctions programs. We can identify the basic target, but if you delve into these sanctions, you find that there's a whole web of related secondary intermediary players who will also be sanctioned in their transactions if, in fact, even indirectly, they somehow benefit one of these targets. So it's a much more complex situation than we might normally think of. What else is going on? Well, there is a resurgence of UN mandatory sanctions. These sanctions, because of Article 41 of the UN Charter, have the result of requiring all member states to put in place implementing rules that they each individually will enforce, which means the web of these sanctions becomes more pervasive than it might have in the traditional situation where you had a single player trying to impose their political and legal objectives on the market. So, for example, coming back to Bob Brain's example earlier, it's not just the EU saying, and we've got to stop this. If it's a UN mandatory sanction, all member states have got to find a way to stop it. And that creates more of a web that becomes the environment against which international and transnational business activity is taking place. Now, before 1990, UN sanctions practice was pretty much limited and ineffective, almost embarrassing at times. Since the first Gulf War and the rather savvy approach of George Herbert Walker Bush, there has been a reliance, a resilience of UN mandated sanctions that means the likelihood one will encounter this as part of the legal background against which a contract is played out is much more likely than might otherwise have been the case. Many states, of course, and the United States is one, will parallel these kinds of multilateral sanctions with sanctions of their own. But there is a more genuinely transnational context within which these sanctions are created. Secondly, you have the emergence of so-called smart sanctions. The idea that unlike traditional sanctions, where you simply say, I hereby prohibit all activities involving country X and all of its nationals and persons subject to their jurisdiction. Boom. And nothing else. Smart sanctions attempt to be more targeted in terms of maybe the target country and specific players who can be identified because they are directly or indirectly involved in the government activity which has prompted the sanctions in the first place. The smart sanctions often go further and will say, oh yes, and anybody who is a middleman, a forwarder, a distributor for these identified people, a financer of these identified people, you also are going to be drawn into the sanctions. And that makes for a more targeted, but often more impactful effect for the sanctions. But notice it also makes it harder from the outside to understand with clarity whether or not you are subject to the sanctions. If you're an intermediary who is dealing with a constantly changing web of players, how do you know? That is to say, before the government knocks on your door. But smart sanctions have increased the impact that economic sanctions policy has on transnational business activity. Further, and finally, you have a more vibrant use of licensing within sanctions program. Many early sanctions programs basically said, we're prohibiting everything, and there might be very limited licenses, particularly for transactions that might have been in transition when the sanctions fell. Now you have sanctions programs where there is a very broad array of licensing programs in place that might allow some kinds of activities, but not others, thus making the sanctions smarter, but also making it more in the actor's interest to approach the government directly and try to work out a license. You don't just hide from them, you try to seek the relief. These kinds of factors, the resurgence of UN sanctions, the emergence of smart sanctions, and the more interactive use of licensing provisions have given economic sanctions more of an active presence in the business world today. So sanctions then will have obviously some impact on contracts. We can see that, but what exactly is that impact, and how does it play out against traditional contract doctrine? And we have here much the same kind of problem that Kate was referring to before. Activity and interactions have moved forward into new planes altogether, and our traditional doctrines kind of move along behind, trying to catch up. Well, take a very simple example. Obviously, if a particular contract is actually prohibited by pertinent economic sanctions policy, the provisions of the implementing regulations typically will declare the contract void. You see that, for example, in the recently renewed North Korea sanctions. The governmental action expressly makes the contract void. If that's the case, we know that that discharges everyone because of the illegality of the contract. The problem I would suggest to you is that very simple, direct situation is less likely to be the one confronting people in the market. Intervening sanctions may also affect existing contracts, or they may have an indirect effect on contracts because of the collateral interest of the sanctions target. The contract may not be with a target of the sanctions, but because they may be a third party or an indirect beneficiary or someone we assume will benefit, that contract as well may be affected, though not necessarily explicitly made void. One might argue that Contract doctrines like impossibility or impracticability or frustration of purpose would ameliorate the impact of some of those sanctions. Unfortunately, interaction of these doctrines with current practices in international business are rather complicated. Under restatement section 261, for example, a party to a contract indirectly impacted by sanctions might want to claim that performance had been rendered impracticable. Yeah, I could physically do it, but the possibility that the goods I'm shipping might get seized make this impracticable. That might discharge the party's duty to perform. However, to apply to this situation, Section 261 requires the occurrence of an event, and I quote, after a contract is made that occurs without the party's fault. What if it's already occurred? What if the problem is we're just realizing that it has an effect? The pervasiveness of a wide array of sanctions programs challenges that premise that it's an event after the contract is made. Sanctions may already be in place. And in the typical sanctions program, the party bears the burden of demonstrating that it did not know and nor had any reason to suspect that the subject transaction was prohibited or restricted. There's a comment to Section 261 that is particularly relevant in this regard. Comment D, you all remember that. What it says is this: a contract to sell, A, contracts to sell, and B, to buy a machine to be delivered to B in the United States. B, as A knows, intends to export the machine to a particular country for resale. Before delivery to B, a government regulation prohibits export of the machine to that country. This is the kind of situation we face on a routine basis in contemporary sanctions practice. Neither A nor B are targets of the sanctions, but the possibility that some sanctioned person or government may benefit from the transaction is going to create the possibility that the sanctions will then be applied to that contract as well. If B can reasonably make other disposition of the machine, even though it's some loss, according to the restatement, his principal purpose of putting the machine to commercial use is not substantially frustrated, nor is it impracticable to continue the transaction. So this notion that, oh, when sanctions come into play, that's it. It's no longer feasible to do this, and therefore we're all discharged, may or may not be the case. Now notice the comment D isn't even going on to the issue about whether or not there might be license policies available that might ameliorate the effect, which means then our assumption that it's before and after. When the sanctions fall, afterwards, we don't have to worry about performing or having any contract liability. Before, maybe we do. There is a mix of results and outcomes because sanctions are now a more foreseeable consequence and context. And that being the case, there is more of a burden on a party to show that they didn't foresee this, or the non-occurrence of this event was something they all reasonably based their performance on. You cannot assume that that will be the case given the prevalence of sanctions as part of our operative world. So illegality and voidness, impracticability, frustration of purpose. We have to begin to think seriously about retooling the way in which we apply concepts like this to what used to be viewed as an extraordinary supervening event, which simply is not as extraordinary anymore. So in conclusion, I would suggest the need for caution and active monitoring of contract activity in the transnational market. It's disingenuous to assume that one can casually rely on traditional doctrines of contracts to avoid unpleasant impacts from emerging sanctions programs. Unfocused reliance on these doctrines can result in a bitter lesson in the modern environment of transnational contract practice. Alive to the possible impact of modern economic sanctions practice, one should consider whether distribution of the potential risk of intervening sanctions is something that should be explicitly negotiated between the parties at the time of contract. And I leave you with that, and I thank you very much for your attention. Now, if only I could figure how to get out of this. Somebody help me.
There should be a stop sharing option, Michael.
Aha.
I can't see your whole screen, but somewhere there's a stop sharing.
Okay.
Maybe down at the bottom of the Zoom meeting screen that has everybody's faces on it.
No, I don't see it.
Or if you go to the bottom of your screen, maybe you can find the Zoom logo and click
Aha.
that, and that might bring up Zoom.
Yeah.
Okay. Let's see. No, that is weird. Meeting controls. Well, this is embarrassing. Goodness
you-
gracious.
Do you
Oh,
see the
stop share.
Zoom?
Got it.
There you go.
There we are.
Hey.
All right. I'd like to open the discussion up for questions. If you unmute and simply tell us, Sidney DeLong, I recognize you.
I liked all the papers, incidentally, and this is just the question that first occurred to me, and I think it probably can be answered very briefly by Dan, and that is everything you describe reminds me of what I studied 50 years ago as being per se violations of the antitrust laws. And I know that anti-competitive agreements like these exclusive dealing things, when they are imposed by states, are ostensibly immune from antitrust liability. But I also seem to remember some cases involving eggs and other farm commodities where the producers had connived to get the state to impose the anti-competitive agreement in the form of a statute. And as I recall, that is not immune from antitrust liability. So I assume that these things had been attacked for a long time on the basis of antitrust. Is there a reason why they survive despite all that?
The specific example I gave with the AB InBev one was investigated by the California ABC, and they were forced to change that. And they have taken on different motivating schemes for their distributors that just kind of skirt the line under the warnings they received from the initial investigation. There have not been a lot of, there's only been a couple that I'm aware of actual government actions or lawsuits on the antitrust front with respect to distributors. There have been, as you probably know, quite a few against large manufacturers, but distributors are now becoming so large that they are drawing the attention of regulators. I would expect to see more coming.
Well, the reason I say that is when I saw the topic that you had about beer, I'm reminded of that. You know, when Homer Simpson says the word beer, and that's this kind of holy tone that he has, that's the same attitude that I have. And I have experienced over the last 2 months an absence of Henry Weinhardt's private reserve in the grocery stores. And I am told it is because the distributor is not making it available. And it's the classic case of an antitrust violation to restrict output. And so Washington State went from a controlled state to a licensed state, I guess, several years ago.
About 5 years ago. Yeah.
But this seems to be a direct consequence on the consumer of an anti-competitive agreement, and it would seem to be a good target for federal attorneys general or private attorneys general under the antitrust laws. But
no, it's a great question. I would like to share with you after I published an article with Gonzaga Law Review on that very topic, looking at California anti-competitive and Washington anti-competitive practices within the beer market. The consensus among alcohol beverage scholars essentially is that that's not the market conduct is not the primary concern of the regulatory agencies. Rather, the focus is on problem drinkers and keeping alcohol out of the hands of minors. There are some enforcement actions, but they're very, very minor given the human power that these agencies have. So I actually advocate for more private suits in that arena.
Very good. Someone else want to unmute and announce themselves? Keith, I
Hey.
recognize you. Keith Rowley.
Keith Rowley from my cubby hole here in Nevada. So Dan, I put something in chat. I have no idea whether you saw it and whether you will be able to see it afterwards. My former colleagues, George and George Shepard at Emory published an article a while ago, 20 years ago probably, on shelving agreements involving soft drink distributors. And the reason why you can find and I think also chips and snacks. The reason why you can find 46 different varieties of Coke or Pepsi, but probably not both. And good luck with the knee high or whatever it might be that you're the yoo-hoo that you're craving on the shelf at your local grocery store, because in order to get priority service from the distributor, the grocery chain is basically, or the independent grocery store, to the extent those still exist, has had to agree to dedicate 80% of its shelf space or whatever to this product or that product. And of course, since then, we've seen these exclusive pouring agreements that universities have entered into with major soft drink companies, where if you and movie chains and whatnot, where if you go somewhere you can only get Coke or you can only get Pepsi products at their various things. And I just wondered whether you've looked at that and seen whether there's anything useful for you in that analysis, or that would clearly distinguish it apart from the alcohol content from what you're looking at.
The key term there, I think, is soft drink. The three-tier system that I mentioned earlier and the Tide House laws that are basically enact that prevent the tiers from sharing a thing of value amongst each other. So a distributor cannot go to a grocery store and say, hey, if you give us 80% of the shelf space, we'll do X. That would be considered a thing of value. And that's actually the statutory term amongst, I think, all of the states, is that this prohibition on sharing a thing of value in consideration for some kind of response. So if you go to the grocery store, right, there's basically two brands of cereal manufacturers. There's all two different companies. There's all different kinds of brands. They don't have that same restriction on sharing a thing of value amongst tiers. That's what makes alcohol different and a little bit unique in that way. I would love to be able to analogize to soft drinks, but soft drinks aren't prohibited from things like shelving agreements in the same way that alcohol is, because of this thing of value prohibition.
Okay. Someone else? By the way, all of the comments that were put in the chat for everyone, those will be part of the recorded report of this Zoom panel, and will be available to all the participants. And I'll follow up on that. Keith, good point. Anyone else want to unmute and announce themselves?
Hi, everybody. Ben Templin here at Thomas Jefferson School of Law. I just want to say this has just been a terrific conference. Really, the themes and everything, each of you, thank you so much for taking time out. That's not really a question. It's just a comment that I really got a lot out of this on the eve of, starting a new class, to kind of say, wow, here are the themes that could be introduced with this new generation of law students. And so thank you, each, and to the commentators. Thank you so much. That's all.
Thank you. Sid, back to you.
Only if no one else has anything to say. But Michael, I was wondering whether your work has led you to any conclusions about what a well-drafted force majeure clause should look like in light of the possibility of trade sanctions. Is there, especially where they don't apply directly to one of the parties?
Yes, this is a difficulty. I've talked, in fact, when I've done the seminar on economic sanctions and trade, we've talked at length about the extent to which a well-drafted force majeure clause might take care of some of these problems. And it in a sense, it really brought me back to what Kate was saying before. Is this something that draws us together or pushes us apart? Now, it depends on how you look at it. Some people, and I could give you some sites for this later on, some people would say economic sanctions in relation to contract drafting is all about risk distribution. The question is, if the sanction hits directly or indirectly our contract, and thus either renders it illegal, which might actually be the easiest situation, or affects the value and utility of it, who wants to get stuck holding that back? And the force majeure clause might offer us a way of distributing or actually sharing that and just saying, no, if something like this occurs, then this discharges all parties' obligations and we walk away. Now, the problem with that is, first of all, again, getting back to this, the negotiating frame of mind, that doesn't necessarily solve the problem, because part of the risk is not just whether or not the contract will end up being illegal and void. It's a dynamic thing. When does it happen? How far has this gone? Who's already expended costs in performance when everything comes to an end? And the problem is, even a well-crafted force majeure clause is not going to help you with that. So the question then becomes, should we, beyond just sort of drop the ball discharge, start thinking about discharge and redistribution of cost? Should we view this as an undertaking we have entered into? And if it's interfered with, how do we want the parties to disengage? And the difficulty, of course, is as soon as you bring that up, the likelihood that people start giving each other the fisheye increases. So how do we get past this? Now, there is one thing that the lawyer can bring to the table that I think might help, and that is to make people aware of just how significant the stakes are. We think about sanctions and it's an embargo, it interferes with trade. There are also criminal sanctions that attach, particularly in most statutes, for knowing or willful conduct, which means the parties need to find a way to disengage in good faith without the kind of maneuvering which may trigger possible criminal sanctions as well. All of that complex of issues has got to be thought about when you talk about force majeure. Now, here's a problem, and I didn't get a chance to talk about this in the interest of time. Those more recent sanctions programs that the Biden administration has put in place, each one of those explicitly and directly talks about contracts. Early sanctions programs tended to just mimic the language of the statute and they would say, pursuant to Section 5, all transactions involving the country of X and its nationals and persons is hereby prohibited. It was only when you got to regulatory implementation that you found out that a transaction in which they might have, and well, that could be a contract, and so we come after the contract. It was always sort of indirect, and this actually helped people because it meant it was less likely that what they were doing would be viewed as knowing conduct. Because, oh, look, we're affected. The latest sanctions programs explicitly say, and if there is a contract that involves any of these specified or described, that's a violation. So the stakes have gone up. And I think now we are living in a transnational world that very directly will use the consequences of contract as an additional level of sanctions. Now, you might say, yes, but contracts, aren't they protected by the Fifth Amendment in a variety of different ways and by the 14th? Well, the case law, at least in the United States, is not very helpful. There are only a handful of cases that even address the issue of whether governmental interference with a good faith contract violates your right to due process, your right to enter into contracts, whether it might represent the taking of property. Very few cases deal with that, and most of them focus on, one, the foreign affairs power of the president, and two, the fact that these are only temporary. And in a combination of those, they essentially will minimize the relevance and impact of constitutional protections of contract, which makes it even more difficult. I suspect, given the more conscious focus on contracts in these latest series of sanctions, it becomes more probable that we may begin to see some case law that reflects on this and really deals with the problem. Concrete example. Coming out of the Iran hostage crisis, which I was involved in, there was a settlement between the two sides that said, okay, we'll bar claims against you in our system. You bar claims against us, and we'll meet at The Hague and work this out. Well, a lot of people in the United States who had claims against the Iran or Iranian nationals felt that this essentially destroyed their contract rights. It was a taking of what was, after all, property. The Supreme Court, when it got hold of this in 1981, basically shuffled that argument aside, and on the basis of the fact that this was all temporary and you have a reasonable substitute for a relief to the extent you're willing to go to The Hague and work this out. Well, that's fairly typical of, that's the Supreme Court. It's fairly typical of the kind of reaction courts have traditionally had to the impact or the interaction between official government sanctions on the international plane and contracts. With the renewed prominence of contracts prohibitions, maybe we'll see something. Yes, Kate.
Yeah, so you had talked about force majeure, and I kind of want to go back to that. We actually would teach the idea of shared risk and shared reward. And so when something happens, I always say business happens, you have to look at the problem and then go back to your guiding principles and say, well, what would I do? Just because I could do this, is that the right thing for the business? right? Would that put the supplier out and I actually needed you? So just because you could do something doesn't mean it's the right thing. So think, for example, Island Health, when the pandemic hit, emergency room visits went significantly up, which were very complex patients, very hard to do. But the general hospitalist, there was no volume. Everyone stayed away. Remember, they canceled all these other surgeries and stuff. So a lot of the hospitalists actually didn't have any work. And the ones that were there were like freaking out, working too hard. So they actually sat down and said, well, when business comes back and we know we're going to need you, how can we actually work to level the load? So all the hospitalists work less. They figured out a way to staff differently. And the hospitalists, no one was laid off, but they all worked less, took over and helped in the ER, level loaded. So no one, everyone loses a little, but there was no loss at the expense of the other party. And so that's how we would try to teach the business people. It's like, all right, well, how would you deal with this? That if something's bad, you lose together and you win together. And so it's not that I won at your expense. And so you work that through your governance structure. And because they had a governance structure and they had practice of using their governance structure in smaller events, when the pandemic hit, they'd already had that muscle memory and that how do I solve big problems like this in a fair and balanced way? And a lot of people would think, we teach, and you're going to freak out here, to not have a termination for convenience. Okay, y'all just had heart failure. But think about it, in a highly dependent relationship, you can't get out of it easily anyway. So we would teach termination for justified business reasons and a really comprehensive exit management plan. So here's when and how I need to get out of this, and here's the way we're going to get out of it in a fair and balanced way. So in reality, you take a very short arm's length clause and you put lots more thought around it.
Yeah. Well, I think, Kate, that gives you the last word. And I want to thank you very much. I've so very much enjoyed listening to this and reading the chat comments and listening to your questions. Contracts in the 21st century may be very scary and very challenging, but my gosh, it's exciting. Thank you all so very much. Matt, you had your hand up.
Oh, no, I was just clapping. Thanks, everybody, for all the wonderful content.
Thank you all. And have a great school year. Bye-bye.
Thanks for putting this together, Michael.
Thank you for coming. Keith, great comments, by the way. I will make sure they all get them. Bye-bye.
Take care.